Welcome back, and thank you so much for staying with us. We continue with the conversation, and in case you're just joining us, we are talking about the state of the judiciary this morning, and we were just, just talking about what needs to be done so that at least the independence of the judiciary can be safeguarded, and the trust that Kenyans ought to put on this very important institution, an arm of government, is reinstated, and that's where we are at. I'd like to run you through some key numbers that were released the other day on 15th when the judiciary was releasing their annual report, and of course just looking at the issue of the case backlog, a step forward there, the judiciary reporting that there's been a 10% decrease in the case backlog. Of course, the pending cases now, according to the judiciary, dropped by about 2.16% from 649,310 to 635,262. This comes from a total of 516,121 cases that were filed in the year that ended in June 30th, while 509,664 were resolved. Of course, we are looking at the issue of e-filing and digitization as well, 100% in all courts. But of course, as it stands, 325,621 files have been scanned. Of course, we also move to the issue of funding the judiciary. This is on the case against cases that have been filed against judicial staff, judges and magistrates. And of course, they received a total of 1,115 complaints. Looking at as it stands today, 93% of these cases have since been resolved. Have we seen results? That's the big question that is still pending there. Of course, on the issue of funding the judiciary, a key concern is the issue of the budget deficit that stands at about 20.75 billion shillings. So according to the Chief Justice, despite the gains, with this sort of underfunding, with this sort of lack of financial muscle, it overshadows every other thing that the judiciary has been able to achieve, and also the plans that they have when it comes to recruitment of judges, and also just sort of like making sure there is the necessary infrastructure to deliver justice. So you look at that budget deficit, 20.75 billion shillings. And that brings us to the conversation we had even started having earlier. The numbers I once interacted with the judiciary was looking at a figure of about 40 billion plus to effectively deliver on its mandate. Right now, it's working with a figure of about 22.4 billion shillings in this billion shillings, which still is running short of what they feel they should be having to effectively deliver justice. The funding of the judiciary, Julie, from where you sit, how significant is it in ensuring that they can actually do what they're supposed to do? Yes, they have their cleaning of the house that they have to do, but the funding issue, how is it significant from where you sit?
It is extremely significant. For ICJ, we have been discussing the issue of judiciary funding since the promulgation of the Constitution. And the Judiciary Fund is actually anchored in the Constitution. And with the judiciary having the requisite funding, it can then develop its programs and ensure that it is kitted to serve the Kenyans in the right manner. So, for example, at the beginning of the year, the projection was that the judiciary would enhance its Court of Appeal capacity by 20 judges. That cannot now be done because they do not have the requisite funding to fund Court of Appeal judges, because people normally assume that Court of Appeal judges are just 20 individuals. But actually, a Court of Appeal judge is a complement, is an office, because that person needs a staff. He needs a secretary, a legal researcher, bodyguard driver, the works. So it is not just getting 20 people in office. It is a big endeavor. You also have the fact that the magistracy is also not funded properly. And you find that the magistracy actually interacts mostly with the Wananchi. They are the first point of call for most Kenyans because of also the pecuniary jurisdiction, but also the proximity. So you find that the magistracy, in terms of its complement, it's not yet at its par. We began the conversation by saying that as it is, the human resource capacity of the judiciary is at 53%. Imagine operating your house with a 53% capacity, meaning you basically don't have half of what you need to do what you need to do. every single year. So credit to the judiciary for looking beyond the GOK funding, involving a lot of development partners who have been able to alleviate some of its otherwise dire situation that it would have been had they actually operated with the current financial constraints. But that is also telling that we need to invest more. A study was done on 11 jurisdictions in Africa which talked about the issue of judiciary funding and how it can be used as a threat and intimidation tool if it is not well ring-fenced. And indeed, for us to achieve judicial independence, it is important for us to talk about judicial funding. Because if you then constrain the funding of the judiciary, you actually water down the independence of the judiciary. The ideal complement that the judiciary would have is 1% of the GDP. It has never gotten close to that. It has been teetering at around 0.4, 0.5. Yet, you would find that its other arms of government are actually well-resourced. And we know that the judiciary is an arm of government, but consistently we find that the judiciary is the one entity that decries underfunding every single time in the budget. I would opine that if we actually gave the judiciary its complement, its funding, we would then be able to then hold it accountable and say that we gave you the funding that you have requested, show us the results and show us the delivery. But if we keep on constraining it on funding, then we actually are asking it to overperform when it is not well resourced.
So we cannot hold it accountable if you're not even giving the judiciary what it needs.
No, we need to hold it accountable still, but we then need to also be able to push as citizenry, as people and actors in the sector, for it to get its full complement. But indeed, accountability, we have to hold it accountable.
Wakili Okach, what do you think, where is the missing link? Because this underfunding concerns, the Chief Justice even says that in the last 3 years, the budget has been cut by about 50%. It's sort of like a trend. Is it just a mere coincidence that as a country we don't have money to give the judiciary, or there is more to why the judiciary is not being effectively funded?
Yes, Safin, your guess will be as good as mine on that issue. Because in terms of allocation of resources, many a times politicians have shamelessly come out and said, you know, because you are doing this, because you are giving, churning out decisions against the executive decisions, at this particular point, we will also deal with you. So ideally, it has been the norm. And you notice during the Emeritus Maraga's reign, especially after he actually nullified the presidential elections, it was quite rough for the judiciary. And they said it outrightly. Come in Martha Koome, and it has actually softened, we have to say. But again, whenever there are decisions, and even as late as early this year, and even as late as during this particular launching of this report, the president himself came out and told the judiciary, no, you must also, you know, muangalie lane, because there are also some things about us that you shouldn't touch. So it was already a threat which was outright, and ideally, these are the same people who are going to decide how much is going to this judiciary. So I think as and when we will do any constitutional reforms, we must then anchor a specific percentage that must go to the judiciary, just like we have anchored it in terms of county governments. We must anchor it so that it does not, you do not need to go and beg. You have noticed many a times, and it is a bit shameful, when the judiciary is actually called into meetings with the executive, and they sit there, and after that, you hear them clapping that we have been given ABCD. That is not proper, because this is even a litigant before you. So you cannot go and get goodies from a litigant who is before you. And that's why sometimes the executive may feel shortchanged, because we have come here, we have given you this, then tomorrow you are churning out. So to an extent, where
you sit following this conversation of funding the judiciary and the underfunding concerns, what do you think should be done to address this sort of like a stick and carrot scenario, the concerns about how money is released from the National Treasury to the judiciary, and the things that we are reading that could be happening to just make the judiciary vulnerable when it comes to the issue of funding? How do we address that kind of a game? Agri, we can't hear you. Maybe just to unmute yourself so that you can give us your thoughts on...
Thank you.
All right, thank you.
Thank you, and apologies for that. I'm saying on the issue of judiciary funding, I will not add to what Wakili Okach has said around having an automatic allocation for the judiciary, because that is important when it is anchored in law, because then that allocation will not be determined by someone or a group or the executive or the legislature, which is also litigating before the judiciary and might want to influence the outcome of a judicial decision. What I think is also important as we look at funding for judiciary is also funding for related agencies or agencies that also work in the judiciary. And I think as we give funding to judiciary, we need to consider from a criminal justice perspective, we need to consider also funding for Office of the Director of Public Prosecutions, and we need to consider funding for law enforcement as well. Because if we only focus funding on judiciary and do not, in the same breath, look at ODPP and NPS, then we will be creating an imbalance in the issue of access to justice. Because if you look at how files come to courts from a criminal justice perspective, they come from the police, then go to ODPP for decision to charge, and then they are then taken to court. And so if we empower only judiciary and we do not empower financially the Office of the Director of Public Prosecutions and also the National Police Service, specifically at the station level, then we will not have done justice to the criminal justice as a whole. And so that is an important aspect that we also need to consider. But as it is right now, we need to have judiciary not only allocated a percentage or a figure by law, but also we need to look at something else in terms of how that amount is applied within the judiciary. In civil society, we have a percentage that we call administrative versus programmatic. So you want to ensure that a percentage of that money goes to administration. That is the per diems, that is the salaries, that is running the offices, running the courts, etc. But also you need to have a percentage of that amount going to the program of the court, so that issues to do with the public sensitization, issues to do with running of CUCs, issues to do with the refund of transport to witnesses, and such other spends are catered for. Particularly in the coast region, we have a lot of cases touching on children, allow me to say this. And you find that most of our courts do not have child-friendly spaces that allow children to feel at home when they come to court. This is something that is very far when it comes to funding by judiciary. And so we are looking at a situation where we need judiciary to also have money that they can use to cover some of these programmatic aspects of access to justice for the people, so that it's not just money that is going to administrative needs, but it is also going to the work, the core work that the judiciary is intended to do.
All right, I agree. And I want us to look at, even as we make calls for more funds to the judiciary, let's look at how this money is spent and where they're getting more money from. There is a tweet by the current LSK president, that is Faith Odhiambo. We know that LSK has raised a lot of concerns, especially when it comes to matters of corruption. And this is what she said in her tweet concerning why they have issues with the judiciary. Of course, she goes ahead to say that while the LSK has remained steadfast in its agitation for a free and independent judiciary, we cannot overlook the overwhelming issues that surmount our judiciary from within itself, whether by runway corruption, outright incompetence, unjustified, or the occasional serving as a conduit for government impunity. Our judiciary has derailed Kenya's efforts towards constitutional consolidation a forthright introspection is long overdue. So issues to do with corruption there, you can see her concern on impunity and how the judiciary has derailed Kenya's efforts for constitutional consolidation. And I want you just to hear your thoughts, because one of the issues we were talking about when we started was the issue of corruption and the need for a cleaning of the house. And hearing where the LSK president is coming from, do these concerns resonate with some of the concerns that you have as well?
That statement by Faith is a very accurate statement. And it emanates from concerns that have been raised by lawyers in various and almost all advocate forums, especially on social media. There have been complaints, especially on two issues: outright corruption and incompetence. And incompetence, I don't think it is deliberate incompetence. It is as a result of corruption. Yeah? And where certain judicial officers will hide behind decisional independence. You see, there is something we call decisional independence, that in the making of my ruling or my decision, I should not be persuaded or compromised by other factors apart from the law as I understand it. Let me put that qualification: the law as I understand it as a judicial officer and the facts before me. So you get situations where you have absurd decisions, yeah, that even the parties themselves know that there are very high chances of a judicial officer has been compromised. Complaints are lodged. Last week, the judiciary was, let me say, gloating, saying that they have resolved 93% of the complaints filed against them. Of those 93%,
1,115.
yes, of the 1,115. 93% resolution, majority of which is sweeping those issues under the carpet, trying to protect their own. Yeah? And that's the reason why some officers are very bold. Yeah? They will always say that this case emanates from the way I handled a certain matter. Yeah? There is no evidence. If you want to prove that I was compromised, don't look at the decision. Give proof that I was compromised. Yeah? You will not trace any money. You will not trace anything that was given to that judicial officer for them to arrive at certain decision. But you will know outrightly somebody has been compromised. We had a case, a very outright scenario. Was it in Kisumu or in sometime last, I think in the course of this year? Yeah? A judicial officer writes a ruling, uploads it, and then the next day he writes a completely different ruling, opposite of what he had done, yes, and it is the one that he had now uploaded to the CTS, yes, is removed from the CTS, and now you have a completely different ruling. Tell me if that is not absurdity, if that is not corruption. Huh?
So how does that even happen? How do you deal with
it? Happens because of impunity, and because they know they are protected within the Judicial Service Commission. There are certain judicial officers and judges who have so many complaints at the Judicial Service Commission, but nothing happens to them. They are protected.
But Wakili Okache, doesn't LSK have a stake in the Judicial Service Commission?
Yeah, LSK has two representatives in the Judicial Service Commission.
And then how does that happen?
But you must understand that those are only two amongst how many? Judges are overrepresented in that particular commission. And it is what we have in terms of constitutional architecture as of now. And you find that sometimes it's very awkward. In the case that I told you, I think 4 of the Supreme Court judges, there are complaints against them. You find that in that particular commission, the Chief Justice, the Deputy Chief Justice are there. There's a representative of the Supreme Court, so 3 are already represented there, and then we have the High Court and the Court of Appeal. So it already tells you, and of course also in terms of the magistrates, but it tells you in terms of how this structure should be. It automatically will mean that most likely, most of these cases, and that's why they're using the word resolved. Resolved is a cover-up. How are they resolved? You see, ideally, you'll find that there's another major case that the other day, the Supreme Court decided because someone has lodged a complaint against some 5 judges or 4 judges, and that was the Tuju matter.
They recused themselves, all of them.
And they decided, without an application for recusal, they decided, because you have complained, we are not going to hear you. Go and wait for the day we will all leave this place, and then you'll come and your case will be heard. And that is up to 2050 something. So someone's case is proper, but the court is telling you, go to hell. And this is a court that is paid, and it is the court of last resort. It means that today, if a contestant, Raila Odinga or William Ruto, maybe utters something and that asks a judge or judges of the Supreme Court, when it comes to a presidential petition, they actually will have the right to say, we will not hear you. You know, and you are the only court mandated to hear this matter. And there is nothing, and it is this is precedent being set, and that's why I'm saying there's need for internal introspection in terms of the judiciary. When you find matters being lodged and someone has said maybe there is need for you to recuse yourself, like we saw in the Rigathi Gachagua matter.
Impeachment
Sometimes
case.
It is important. You may not even be it may not even be true. It may even be false. But if there is another court that can hear this matter, and a process is there, sometimes it is good to recuse yourself. But to that extent, if you proceed and we come out with, we have results which are outrageous, like what Kamande has said, it will lead to matters going to the JSC. You'll find that JSC, unless it is a very big matter where, like the one for Justice Chitembo, where a politician was the one who was complaining and shouting all over, it will be dealt with in record time, and you'll find that the result will actually be what you'd expect. But many a times, these are the matters, and I think that's why the other story was in the papers. Unless it is promulgated in such a manner, you'll find that it will be swept under the carpet. It is important for JSC to give confidence to Kenyans. Remember, JSC came into place because before we didn't have it, and we had to do radical surgeries, left, right, center. And at that point, if you sat or heard or even review those particular clips, you'd wonder. A very sad affair,
it's a
because
very unfortunate scenario.
The judiciary should be like Caesar's wife, beyond reproach. There should, even that thought, and I like what you are telling Murigi Kamande, even that thought alone should not be there, that this judiciary can, mtu anaweza kuwa amepewa kitu. It should never be, because the moment that happens, Kenyans will not trust the judiciary with their cases. Then they'll resort to the rule of the jungle. That is what led to 2007. Yeah. It starts small, it will even end up big. So the judiciary is so sacrosanct, so important in terms of the aspect of this particular country remaining as a unit and developing and transforming, such that if we do not even have proper judges who can make decisions based on the law and the facts before them, it does not matter how much we will put in that judiciary. You say 40 billion, even if you put 80 billion. It will still not matter, because it negates the very essence of the judiciary. Because the man is insatiable when it comes to money. So if you can bribe a judge, that thought alone of a judge being bribed, because there is no other way that a judge can come up with 2 decisions. And it is not the first time. Even during that particular time when there was the Justice Kuloba issues and others. And I remember even when he was teaching us, there was that issue that it is possible for judges to actually decide either way, depending with money. But one thing I will tell you, not all judges are corrupt. I can tell you we have so many judges, and as lawyers, even among ourselves, you'll hear someone telling you, this one, no matter what, this person will remain true and faithful. But we have others that even lawyers still depict as questionable, and people talk outside here. So sometimes it is good, and that's why I'm saying the only way now to deal with the judiciary is not through the JSC. It is to do another. I think the radical surgeries will always be the way forward.
But how many, Julie, how many radical surgeries will we have then? Because if we are saying that corruption is a reality within the judiciary, but then we are also poking holes in the effectiveness of the Judicial Service Commission, I mean, my biggest fear is what he was saying, a time when we will now resort to the rule of the jungle and Kenyans would be feeling like, hakuna haja hata nipeleke kesi yangu kotini. How do we avoid getting there? Because we know the consequences of that as well.
I think it's important that we actually do take a moment and appreciate the consequences of the rule of the jungle. I think 2008 was a very telling time and a sad time in our history. And for those of us who are alive and witnessed the atrocities that took place because of the inability of the judiciary to guide the country and steer the country away from that, we understand and appreciate why the judiciary and the JSC in itself were created. So talking about the current state of the judiciary in terms of accountability, indeed the statistics say that 1,115 cases were filed this year, a decrease actually from last year where they had 1,200 cases. I would wish that there was a narrative around why there was a decrease in the number of complaints, because also a decrease in complaints is a very telling story juxtaposed against what the public is saying. So that should also be a cause for concern. 2 weeks ago, the Supreme Court was having its introspection and reflection at Supreme Court at 12. I would opine that it's also important for the Judiciary Service Commission to consider having a reflection of the same kind, whereby they invite stakeholders to really tell them where the shoe is pinching. Indeed, the JSC has representation from the Law Society of Kenya, 2 people, but as rightly said, the numbers from the judiciary are much more. But there's also the Attorney General. There are also members of the public who are there and they represent all our interests. So what is happening at the Judicial Service Commission where nothing is supposedly seeming not to move? So can we have a conversation around why things are not moving at the Judicial Service Commission? Or at the same time, can we have a conversation around whether Kenyans appreciate or utilize the Judicial Service Commission for complaints? Because there has also been a decry from the Commission that enough conversation is happening in the public sphere around corruption of judges and magistrates, but they're not getting those files. They are not getting those complaints registered before the Commission. So do people even know how to file these complaints? Do we have evidence of complaints filed and no action taken? And I do believe this is then a challenge to the Law Society of Kenya, civil society organizations that work on the issue of democracy and governance to actually interface with the JSC and ask those difficult questions, because appreciating both dynamics whereby you have to protect the judges and judicial officers who are innocent until found guilty of the dispute resolution process, but also the client who's then complaining, we need a sort of in-camera conversation whereby the Judicial Service Commission can report and say, this is where we are at in terms of complaints. These are the matters that have been taken for further investigation. We appreciate the way in which a judge can be removed from office. It is not that easy. We require an entire tribunal. And in order for us to have a recommendation from the Judicial Service Commission for a tribunal to be constituted, the evidentiary threshold must be met, because you cannot then move these processes at will, because then they'll be exploited. So there's also a threshold that has to be met. So what are the bottlenecks that the JSC is facing? Is it lack of evidence? Because indeed, we appreciate that sometimes corruption is very sophisticated. Do they not have that kind of evidence before it? How can we assist as lawyers? Because for us, even out here, when we are campaigning for the judiciary to be fully resourced, we get backlash and we are told you are resourcing an entity that is morbidly corrupt. So it's in our best interest as well to ensure that the judiciary is clean. So I think it's time that the JSC come out, talk to people, engage the public around the complaints mechanism and how to actualize it. But also ensure that Kenyans understand the differences between appeals and complaints, because there are certain matters that actually Kenyans take before the JSC that actually should go through the appellate processes, whereby someone is dissatisfied with the outcome of a case. That isn't necessarily an issue of complaint, but an issue of appeal. But we have also talked about the issue of the human resource capacity and constraints. If a party is dissatisfied with a matter that they have gotten, or a decision they have gotten from the High Court, for example, and then you lodge an appeal, but the appeal takes 15 years. You are then frustrating this person because you're telling them you cannot complain before the JSC because this is judicial decisional independence. You need to appeal. the appeal takes another period of time that is quite long. And at the same time, they don't have a recourse before the JSC because they are pending this appeal to be determined. So you find that someone is stuck between a rock and a hard place, and that is why the public is decrying that there is a challenge in the judiciary and there's a need for a conversation around judicial accountability. I would not be the first proponent for vetting because, again, it was subject to abuse. The reports are telling that some people just did not like how you speak. And they used the vetting process to get rid of certain good judges and magistrates because they were too tough, because they were too bold. So it is subject to also manipulation based on the interests, political interests. So I think let's work with what we have as per the Constitution. Let us strengthen the JSC and let's hold it to account. I would then opine that it's important for the lawyers to have a conversation with their representatives at the Commission for a candid conversation around what is happening there, as well as for the others who are working with the judiciary to also, particularly for judges and judicial officers, to actually ask for judges and judicial officers who are representing them in the JSC to hold the judges and judicial officers to account, because one bad apple spoils the basket. If they continue watering down these matters, then the entire judiciary gets the flack. Thank you.
And we can imagine the darkness that we will be in if that happens. Exactly. Because the judiciary, I see it as the only institution that from my point, should and needs to be objective, because the other arms of government sort of like have at the background the political interest that needs to be served at the end of the day, which sometimes can come in the way on some of the things that are done in this country. And Agri, just to get your point also, what is going on, there's been talk about the interconnectedness of these three arms of government. What's the best way of drawing the lines? Because there's been concern about how these lines are increasingly becoming transparent, blurry. You can't really tell which the executive suddenly you hear has taken over the legislature. You hear now the independence of the judiciary is being compromised. How best should we have that interconnectedness? Because some argue they cannot operate in isolation, but how do they work together and still serve their mandate without really compromising their own independence?
Thank you for that question. I think it's in the issue of what we call separation of power. And the architecture of the Constitution is such that they are allowed to work together, not to work in isolation, but also each of these three arms powers or certain checks to ensure that they are not influenced by the other arms of government. And so you find that Parliament, in exercise of its legislative authority, cannot be influenced by courts. You can go to court on issues of process and other kinds of procedural issues in Parliament, the legality of procedure. But when it comes to the decisions they make around legislation, you can only talk about the unconstitutionality of the outcome of a legislative process, for example. And so it allows Parliament to be able to engage or to do its work without significant interference from outside. Now, if you look at Parliament right now, it is said to have been captured by the executive. And that is in the nature of the relationship between the parliamentarians and the executive in the presidency, or even the executive, quote unquote, in the leader of opposition. Then when you come to judiciary, on the other hand, there is a bit more challenge that limits its separation from the other arms of government. Because when it comes to allocation of funds, there is a role that Parliament plays, and there is a role that the executive plays. Given this administration gave the judiciary fund to the judiciary, but the fact that it took an executive order or an executive authority for that to be done is a challenge, And so you see a situation in which the hand that gives could also be the hand that takes away in that situation. And so what we said earlier around having allocation that is anchored in law is very important to ensure that we do not have the kind of influence that can negatively impact the judiciary. And that is just one. I think we have also seen in the last 2 years very high-profile government officials criticize individual judicial officers' decisions when it comes to decisions they made on certain matters. And I think it was as high as a deputy president. That is also concerning, because when it gets to a point where an individual, a judicial officer, as an individual is called out for a decision they've made, as sitting as a court, then that is problematic, and it is something to be rebuked, and if possible, even to demand accountability for. And so, as we sit here currently, I think when it comes to separation of power in terms of a concept, the constitutional architecture is fairly good. But when it comes to the practicalities, especially of funding and other influences like security for judiciary, we have a long way to go. And those are things that you need to probably look at more in depth.
All right, sort of like it's undertone, like it's control that is being done not directly, but through other mechanisms, through funding, through control and threats and intimidation. And this we've seen over time, not just even this current regime alone, but the history of this country has shown us a lot. I want us to listen into what President William Ruto said just the other day when he was giving his State of the Nation address. He actually blasted the judiciary and DPP over laxity in the war against corruption. We just want to listen into what he was saying. For him, he was just calling for greater accountability and efficiency in handling corruption cases in the country. His major concern was the dismissal of cases by the DPP, and also how corruption suspects are given an opportunity to just walk scot-free, delaying proceedings by seeking anticipatory bail. And let's listen into what the president was saying and look at what impact this really has in the war against graft in the country.
Let me say this. It cannot be the case that the Director of Public Prosecutions keeps dropping cases because somehow they are unable to produce witnesses. It cannot also be the case that corruption suspects rush to court to obtain anticipatory bail that shields them from due process and enables them to compromise investigations. There is also no reason for corruption cases to drag in our courts for years, when the same courts are able to determine election petitions and related disputes within 6 months. Members, it is also unacceptable for the Houses of Parliament to deny the nation a much-needed instrument in the war against corruption by continuing to sabotage the passage of the Conflict of Interest Bill. I implore you, honorable members, to stop dragging your feet on this bill, unless, my friends, there is a conflict of interest in the passing of the conflict of interest legislation.
Right. A light moment there by the head of state, but he was making a very serious point, regardless of, how that attracted reaction from the members of parliament. But most importantly, Wakili Okachi, is the concern about how corruption suspects are using the court system to their advantage to slow down their cases, and the concern is that this is slowing, is actually affecting the smooth investigation that ought to take place. I mean, just also weigh in on this, and has the court failed us? There was a time they were branded the weakest link in the war against corruption. Are we still there?
I don't think we are actually there. First of all, we have an anti-corruption division, which is actually very robust and fully fledged with the High Court dealing with anti-corruption matters. So if you look at that, they've really been churning out and working, and we partake these services daily in that particular court. The only thing that the president must understand is that in terms of rights in the Constitution, they can be abused by anyone, including officers, including complainants, sometimes even the DPP. So to that extent, the right to actually seek anticipatory bail is actually a right that protects. And many a times we have seen, cases being brought in and they are malicious, fictitious, and none other than the president, when he was deputy president, cried and talked about this particular issue. And he said people had weaponized, the criminal justice system. And if it wasn't for for these constitutional courts issuing such orders, many of the people supported him would have languished in jail. And I partook in instructions in defending many of those people. So today, if you wear the shoe on the other side, it doesn't mean that now that becomes a wrong thing. Remember, even these courts will look at what has been filed. And in the fullness of time, if there is no merit, the court will actually dismiss. So it is a process that is there to protect. But more importantly, again, the moment the president says that, because petitions can be dealt with in 6 months, every other case, there is a possibility of doing that. I think that's not quite factual in terms of what happens, because many times lawyers, because of that condition or that provision, lawyers set aside all what they need to do and prioritize this. Courts put aside many cases and prioritizes it. So many cases suffer in the meantime. So the essence is to deal with backlogs, ensure efficiency, so that we are at a point where we can easily deal with cases in real time, like we have seen in many jurisdictions, and it is possible.
All right, it's
another thing that I think would actually help, sorry for that, is you see in America, and like even in the International Criminal Court, they have something that we call before the case, there is, you go like a pre-trial chamber. A judge can sieve and see everything that is there, so that if the DPP has brought a case, and of course it is political or it is malicious, you do not have evidence, it is actually dismissed at that point before going to the main case. And that is what happened when Trump tried to file his petition the other time against Biden. It didn't even see the light of day. So sometimes we have to try and have that sieve mechanism, and that behoves the DPP to ensure also that he also sieves cases, so that we do not have cases that go to court and the cases, first of all, do not have the bare minimum evidential value, but more importantly, in terms of withdrawals. The withdrawals, if it is because witnesses have failed to come, the DPP can do nothing about that. But if it is because, ideally, the case itself, you have reviewed and you're saying this case has no basis, sometimes a question mark can actually be there. But the DPP has that right in law to actually review these cases at any given point in time and make decisions, so that he does not push cases in court for no good reason. Lastly on this issue, my sister has told me that, sometimes these judicial radical surgeries are misused. And the examples she gave, I'm telling you, are actually may not be sitting proper in terms of what is expected of a judicial officer. Socrates told us that, a judge is supposed to listen cautiously, answer wisely, consider soberly, and decide impartially. Those 4 tenets must be clear, so that even as a judge, you cannot be seen to be irrational. You cannot be seen to be someone who is temperamental. There are those sieve mechanisms which are important, and that is why sometimes when people lambast Uhuru Kenyatta, he's a consumer of intelligence reports. And these intelligence reports must find its way to the JSC when they are recruiting. Because it's very, very important to know the background of the people you want to employ. So that if intelligence reports do not find their way there, or find their way and with one reason or another finds their way outside and does not reach the plenary, it then means that you may end up also bringing into the judiciary.
But Wakili, having said all that, why does it seem that what all you're saying works only when it comes to the high-profile cases, the high-profile people? Why does it seem like it's skewed? When it comes to the common mwananchi, it doesn't work that way.
You see, the problem with that is the perception that has been created. Because the media will focus on, cases where high-profile people are, because that is what is news. If you go and focus on what some Mama Mboga was doing there in court, many a times it doesn't make news. It's not juice for you. So people will assume that when there is an acquittal, when the High Court has overturned a decision of the lower court in a high-profile case, that becomes the norm. But ideally, the judiciary, in terms of this particular process, works the same, save for certain instances where there are those aspects of corruption. And that is why, once you deal with the aspect of corruption, you'll never come to ask that question, why does it work for other people? Because you are saying that because madly in your mind, there's that indication that Kenyans always have, that there's something that these high-profile people do which a normal Kenyan cannot do.
Julie, what do you think? Is it a creation of the media? Haven't we seen instances in this country where cases that involve high-profile people drag? This war against corruption, looking at it, is it an area where the big fish continue to swim and the small fish, fry? From where you sit, just looking at instances we've had in this country.
I think, so I have two issues here.
Yeah.
I do the work around elevation of poverty and also looking at the small fish, the Mama Mbogas. And as Agri said in the beginning of the conversation, in 2017, the National Council on Administration of Justice actually released an audit that stated that 70% of the persons who are in detention in pre-trial are actually poor, vulnerable, and they're there for petty offences. And translating now into the detention, they were there because they could not afford the fines that were imposed by the courts. So you find that in the detention facilities, we have people who are poor, vulnerable, and indigent. So that is the demographic of people we have behind bars. What does that mean? It means that the people of wealth, the people of corruption, the people who are charged with corruption matters, more often than not, do not go to the detention facilities. Why? Because they can afford advocates, because they can actually mount a proper defense. So, in terms of the anti-corruption war, the corruption war, we have seen challenges, and particularly challenges bedeviling the entire criminal justice system from the corruption, from the entities that are seized with investigating corruption. DCI, ESCC have investigative powers. They're supposed to create files that are actually full of evidence and ensure that they meet the evidentiary threshold so that the prosecution can actually give a decision to charge on the basis of a probability of conviction. Do they forward the cases as they should be? Because we saw from the previous DPP that a lot of the cases ended up being withdrawn because of the promise of evidence to follow after after the decision to charge had already been put in place. So a lot of cases were frustrated. I think it was either your media house or another media house that actually brought the DPP to actually answer and ask those questions. Why are matters failing in court? And he did say that at the investigation stage there was a gap. So for the issue of corruption, I think we need a whole of justice approach. We need to start at the investigation level. How is investigation being carried out? How is evidence being collected? How are witnesses being protected? We need to capacitate the Witness Protection Agency because witnesses, particularly of corruption cases, are often targeted. Right now, we are seeing that the Adani situation has blown up. But where is the initial whistleblower? He's not in the country. He's not even on the continent because of the threats that are actually on his life and on his person because of what he then said. So I think we need to strengthen the government entities that actually do the investigation, protection of witnesses. But then we need to also call and hold the DPP to account. You need not prefer a decision to charge if you do not have the evidence because, again, that is a violation of the rights of the person who is then charged. You need to return the file to the various investigative agencies and ask them to provide the requisite evidence for you to be able to bring these cases to court. I actually agree with counsel here when he says that, indeed, once the matters are before court, there ought to be a sort of mechanism whereby evidence can be presented before the magistrate or the judge, depending on the level, and they look at the evidence before them and say that this matter can then be set for hearing and can proceed. Because then we end up not having a situation where the matters are withdrawn in the middle because witnesses are not there. But we also we can borrow innovation from other countries whereby evidence, particularly of witnesses who are vulnerable, can be taken in camera and preserved early enough. Because we have seen instances where these witnesses are compromised, but also these witnesses are actually threatened. So let's devise those mechanisms. And I know at the National Council on Administration of Justice, there is an entire committee that is seized of this issue that is going to be developing an anti-corruption framework that is due to be launched very soon. And this framework will actually guide the entire criminal justice system on how it should address corruption, and with the requisite goodwill from all actors, and particularly political actors, we will then be able to fight corruption. And I actually agree in tongue-in-cheek with what the President said at the very end of his statement, that Parliament also needs to be able to safeguard the country. Certain bills should be put in place, including the issue of conflict of interest. You cannot have politicians also engaging in procurement and also service delivery because they are supposed to just maintain their role, which is legislation, of, oversight and the rest. So I think there's been a meddling of the waters, and that is what has created this current conundrum we have in regards to corruption.
All right.
Yes.
I'm almost running out of time, but
Yes.
I want to, just also hear your thoughts on how do we balance between the constitutionally protected rights of the suspects and the need to deliver justice when it comes to a war such as a war against corruption, so that these rights are not abused and they do not thwart the efforts that we are trying to put in place as a country to fight corruption. Because we cannot just be this helpless and say they have a right to anticipatory bail, they have a right to this, so there's nothing we can do. I mean, yeah?
Now, allow me to make this comment. And I believe that when the President was making those remarks, he was not being honest. And the reason why he was not being honest is because he knows two things. When you talk about the executive, the DPP is an extension of the executive. We have to be very honest. Even if it is called an independent office, it is not one of those properly independent offices. Yeah? They at times act at the behest of the executive. Yeah? So we've seen a situation where you have, and the cases that have been going on corruption, you have these push and pull, or this tussle between EACC and DCI. And then you have ODPP on this other side. So EACC says DCI has no mandate to investigate corruption cases. Yeah? But EACC on the other side says we are the one, DCI says we have powers. And then the liars with ODPP. You have a situation where now you go to court, DCI and DPP are on one side, and then EACC is on this other side. Then the DPP goes ahead and makes an application for withdrawal of a matter that was investigated by EACC. EACC opposes such an application. The court is now in a conundrum. Do we believe the investigators, or do we believe the ODPP who says that they have power to determine whether to proceed with a prosecution or to terminate it?
All right. Commander, thank you for saying that. I'm really pressed for time. And this conversation has just gotten quite exciting. Thank you, gentlemen and lady. I'll have to cut you short there and cross over gears to the next interview that we had lined up this particular morning. I've been having a conversation with Wakili Duncan Okach, an advocate, Julie Wayua Madheka, Program Manager, Democratic Governance, ICJ Kenya, Murigi Kamande, an advocate, and Agri Juma, who's joining us virtually, the Senior Manager, International Justice Mission. Thank you so much once again for creating time. Now, in just a bit, we'll be crossing over and looking at matters gender-based violence, just looking at efforts that are being put in place to make the space safer for women, for girls, especially during this season that we are marking the 16 days of activism against gender-based violence coming up shortly. Don't go too far to stay for that and much more.